sample legislation that we would have had to consider for the future has not fully been assembled yet and is not available to us. One of the things that we sent to our members were copies of last year's New Jersey and Vermont legislation, which similarly to Connecticut did not get passed, and it was similar to ours in its structure as well, and we disseminated those electronically for our members to look at, so that after our guest speaker, we'll have a brief discussion on some model legislation that we'll be looking at to continue on to the future. So we'll get right in. I also wanted to mention that it had been requested of us that we should try to learn as much as we can as legislators about the Food and Drug Administration process. And to that goal, we had invited members of our congressional delegation to come today, particularly Congressman Courtney, who sits on the Agricultural Committee and is one of the first Connecticut legislators on that committee in a long time, but they're all very busy in Washington as we speak, trying to avoid the so-called fiscal cliff. So we may possibly see if Congressman Courtney in particular may come and speak to us in the future. But in a moment, we're going to go to our guest speaker, and that's Stephen Druker. Stephen Druker is someone who knows the FDA process. I will say, going into this, that he has found fault with it, and he will explain that momentarily. Hello there, Mr. Druker. How are you today?
Can you hear me okay?
Yep, we can see you. Can you hear us okay? No?
Yes, I can hear you.
Okay, very good. Well, welcome to Connecticut and the land of steady habits. And we're so grateful you could Skype into us. I'm Representative Philip Miller. I'm joined by several other members of our legislative task force. And we're very honored to have you with us today, Mr. Druker. And I don't have your biography in front of me, but I'd like to go right into you, and if you would give us a brief introduction and then speak to the FDA process and any other pertinent information you'd like to give us, sir.
My name is Stephen Druker, and I'm a public interest attorney who is the executive director of the Alliance for Biointegrity. And I think I'll launch into it from there, and then there can be follow-up questions if you want to know more about my background. I'm happy to have the opportunity to speak with you this afternoon, and I thank you for providing it. I'll be addressing two basic issues. First, to what extent has the federal government, particularly the FDA, preempted the regulation of genetically engineered foods, especially regulation in regard to their labeling? Second, is the FDA actually doing its job in regard to genetically engineered foods? Is it truly affording American families the protections that are mandated by federal food safety law? As you will see, the evidence provides clear-cut answers to both of these questions. For one thing, it establishes that the FDA has not preempted any aspect of the regulation of GE foods. Moreover, the evidence also demonstrates that the FDA is not even doing its job. Instead of upholding the food safety laws and preventing any genetically engineered food from entering the market until it has satisfied the law's explicit requirements, the agency has arbitrarily and illegally exempted all of these foods from the safeguards that the laws have carefully set in place. In the process, the FDA has also illegitimately evaded the law's requirements that material facts be disclosed through labeling. Accordingly, it appears that there is ample room and ample justification for the state of Connecticut to enact labeling legislation, or to enact legislation requiring that these novel foods at least be labeled. Now, before presenting this evidence, I want to clarify a procedural point. As the executive director of a nonprofit 501c3 organization, it is not my role to engage in lobbying activities. and I'm not here to advocate that you enact any legislation. Rather, I'm here solely to present information that will enable you to deliberate based on accurate understanding of key facts that are not yet well known. And while I'm on the topic of gaining accurate understanding, I'd like to note that the task force is fortunate to be able to rely on the organization GMO-free CT and its highly competent leader, Tara Cook-Littman, as a valuable source of information. So let's consider the first issue. Has the FDA preempted the regulation of GE foods? Now, answering this question is straightforward because the FDA has explicitly stated that it is not regulating these products in any manner. The agency has pointed out that it has not promulgated any substantive rules regarding GE foods and has merely issued a statement of policy which is totally non-binding. Non-binding both on the FDA and on the manufacturers as well. In fact, the agency has declared that its policy statement is so passive that it does not even legally qualify as agency action. For instance, the FDA has asserted in federal court that the minimal nature of its policy exempts it from any duty to conduct an environmental assessment of GE crops according to the mandates of the National Environmental Protection Act. The agency argued that its policy is not subject to these requirements because it does not regulate GE foods in any manner and is therefore not an action sufficient to trigger the application of the statute. In advancing this argument, the agency emphasized that the primary feature of its policy statement is a mere presumption that these foods are generally recognized as safe. Just a presumption. Moreover, it stressed that this presumption is fully rebuttable and that it does not therefore constitute significant action. Now, the judge in that case agreed with the FDA's contention. She declared that its policy on genetically engineered foods is essentially one of inaction. That was her word, inaction, to the extent that it does not even trigger application of the Environmental Protection Act. Thus, although biotech proponents commonly claim that the FDA is regulating GE foods and carefully monitoring them for safety, in reality, it's not regulating them one iota. And whatever guidelines it has disseminated to the manufacturers of the foods are not binding rules, but are purely voluntary suggestions. As a federal judge has pointed out, the agency's policy does not impose any obligations on the biotech industry. Accordingly, it's difficult to see how the FDA could successfully challenge a state statute that imposes some degree of regulation on GE foods by claiming that it has already preempted the field through its own admitted inaction. But there's another reason that any state would be well within its rights in enacting legislation that regulates GE foods. That's because not only has the FDA failed to provide any regulation of them, its failure constitutes an abdication of duty. And in abdicating its duty, the agency has allowed GE foods onto the market in violation of federal law. Now, I realize that this may seem like an extreme statement, but the facts solidly back it up. So let's briefly examine them. The Food Additive Amendment of the U.S. Food, Drug, and Cosmetic Act institutes a precautionary approach, and it requires that new additives to food must be demonstrated as safe before they are marketed. An official Senate report described the intent of the amendment as follows, quote, "While Congress did not want to unnecessarily stifle technological advances, it nevertheless intended that additives created through new technologies be proven safe before they go to market," unquote. Although the FDA admits that the various genetic materials implanted in bioengineered organisms are within this amendment's purview, it claims they are exempt from testing because they are generally recognized as safe, or to use the common abbreviation, GRAS, G-R-A-S. However, the FDA's regulations state that substances added to food that were not in use prior to 1958 cannot qualify as GRAS unless they meet two requirements. Not only must they be acknowledged as safe by an overwhelming consensus of experts, but this consensus must be based on, quote, scientific procedures, unquote. And these scientific procedures, according to the regulations, ordinarily entail studies published in peer-reviewed journals. Now, FDA regulations further stipulate that these scientific procedures must provide a demonstration of safety, and that GRAS substances, quote, require the same quantity and quality of scientific evidence as is required to obtain approval of the substance as a food additive, unquote. Thus, it's clear that the GRAS exemption is not supposed to reduce the degree of testing, but rather to relieve a producer from performing new tests for substances already known to be safe on the basis of previous ones. Now, genetically engineered foods fail both requirements. There is substantial dispute among experts about their safety, and none has been confirmed safe through adequate testing. As the FDA was developing its policy on GE foods during 1991 and 1992, there was not even consensus of safety among its own experts. The predominant opinion was, A, that these new foods entail unique risks, especially the potential for unintended harmful side effects that are difficult to detect, and B, that none can be considered safe unless it has passed rigorous tests capable of screening for such unintended effects. These scientists expressed their concerns in numerous memos to superiors, memos that only came to light in 1998 when, under my direction, the Alliance for Biointegrity initiated a lawsuit that forced the FDA to divulge its files. For example, microbiologist Dr. Louis Priebel stated, there is a profound difference between the types of unexpected effects from traditional breeding and genetic engineering. And then he added that several aspects of gene splicing, quote, may be more hazardous, unquote. Similarly, Dr. E.J. Matthews of the FDA's toxicology group warned that, quote, genetically modified plants could contain unexpected high concentrations of plant toxicants, unquote. And he cautioned that some of these toxicants could be unexpected and could, quote, be uniquely different chemicals that are usually expressed in unrelated plants. Citing the potential for such unintended dangers, the director of FDA's Center for Veterinary Medicine, CVM, called for bioengineered products to be demonstrated safe prior to marketing. He stated, quote, CVM believes that animal feeds derived from genetically modified plants present unique animal and food safety concerns. He explained that residues of unexpected substances could make meat and milk products harmful to humans. In light of these unique risks, agency scientists advised that GE food should undergo special testing, including toxicological tests. The pervasiveness of the concerns with the scientific staff is attested by a memo from an FDA official who protested that the agency was, quote, trying to fit a square peg into a round hole by trying to force an ultimate conclusion that there is no difference between foods modified by genetic engineering and foods modified by traditional breeding practices. She then declared, the processes of genetic engineering and traditional breeding are different, and according to the technical experts in the agency, they lead to different risks. Moreover, FDA officials knew there was not a consensus about the safety of GE foods among scientists outside the agency either. For instance, FDA's own biotechnology coordinator acknowledged in a letter to a Canadian health official that there was no such consensus in the scientific community at large. And a copy of that letter, along with the other FDA memos, is posted on our website, biointegrity.org. Dr. Mariansky also admitted, quote, "I think the question of the potential for some substances to cause allergenic reactions is particularly difficult to predict," unquote. This lack of consensus in the scientific community itself disqualifies GE foods from GRAS status. But even if consensus did exist, and even if it was unanimous, no GE food would qualify as GRAS because none has satisfactorily passed the level of testing that the law requires and that the FDA experts stated is necessary. The agency's files demonstrate that as of 1992, when it issued its policy statement, there was virtually no evidence to support safety. And one official's memo to the biotechnology coordinator queried, quote, "Are we asking the scientific experts to generate the basis for this policy statement in the absence of any data?" And the evidentiary base is still deficient because the FDA does not require any testing, and the tests relied upon by the EU, Canada, and other nations do not adequately screen for the unexpected side effects about which the FDA scientists warned. The inadequacy of current testing has been pointed out by numerous experts, including the Royal Society of Canada and the Public Health Association of Australia. Despite the ample evidence indicating a lack of consensus about safety, as well as the lack of requisite evidence to confirm it, the FDA's decision makers, who, by the way, acknowledge they've been operating under policy to foster the U.S. biotechnology industry, declared it is legitimate to presume that all GE foods are GRAS, and that they can therefore be marketed without any testing. In doing so, they profess themselves not aware of any information showing that GE foods differ from others, quote, in any meaningful way, unquote, despite the extensive input from their scientists pointing out the significant differences and their serious implications for human health. In light of these facts, I think it's obvious that this claim of not being aware of any such information is false. And it's difficult to view it as anything but a deliberate falsehood intended to deceive Congress and the public. It's also difficult to accept that the FDA administrators sincerely believed that all GE foods are GRAS when they knew there was compelling evidence that none of these products had fulfilled either of the two requirements for GRAS status. Consequently, any reasonable man or woman can justifiably draw the conclusion that the FDA administrators ushered genetically engineered foods onto our supermarket shelves by covering up the warnings of their own scientists, lying about the facts, and intentionally breaking the law. Moreover, even if one were to be extremely charitable and grant the FDA so much discretion as to somehow legitimize the presumption of GRAS it made in 1992, that presumption was a rebuttable one. And it's obvious that it has been repeatedly and thoroughly rebutted. For instance, in 2001, an expert panel of the Royal Society of Canada issued an extensive report declaring, A, that it is, quote, scientifically unjustifiable, unquote, to presume that GE foods are safe, and B, that the, quote, default presumption, unquote, for every GE food should be that the genetic alteration has induced unintended and potentially hazardous side effects. The British Medical Association is one of the many other respected organizations that has expressed reservations about the safety of these novel products. As described in the British Medical Journal, the association released a 2004 report stating that, quote, more research is needed to show that genetically modified food crops and ingredients are safe for people and the environment. This is hardly evidence of general recognition of safety. In fact, it's evidence that there is no such consensus about safety. And I have to emphasize the requisite evidence to establish the safety of GE foods has, as I speak, still not been generated. As David Schubert, a professor at the Salk Institute for Biological Studies, has recently written, quote, as a medical research scientist who published a comprehensive peer-reviewed critique of genetically modified food safety testing, I can state confidently that it is false to say such foods and the toxic chemicals they require are extensively tested and proved safe. No producer-independent safety testing, long-term or multi-generational rodent studies, or epidemiological studies have been done to support the hypothesis that these foods are safe, unquote. So in light of all these facts, it's compellingly clear that none of the GE foods currently on the market is generally recognized as safe according to the dictates of federal law. Now, what about labeling? How does it relate to the GRAS issue? The answer is, quite directly, because the issue of labeling is intimately linked with the issue of whether GE foods are GRAS. The law requires that material facts about food be disclosed through labeling. However, the FDA contends that the fact the food was produced via recombinant DNA technology is not material, even if there's widespread consumer interest in knowing that fact. The agency asserts that unless a process entails unique risk to human health or causes a uniform change in the food, its use is legally immaterial, and there's no duty to inform consumers about it. A federal court has upheld this interpretation of the law, and it has also deferred to the FDA's determination that GE foods do not, in the agency's words, present any different or greater safety concern than foods developed by traditional plant breeding. Accordingly, the court ruled that the FDA has no obligation to label these foods. Thus, the court linked the labeling issue to the GRAS issue, in effect holding that because the FDA was entitled to presume that GE foods are GRAS, it was also entitled to reject consumer demands for labeling. But since it's obvious that the FDA's rebuttable GRAS presumption was not made in good faith, was unwarranted when first announced, and has thereafter been solidly rebutted, then it follows that the FDA's argument against labeling has also been refuted. Thus, it's also obvious that the fact that food was produced through genetic engineering is a material fact that should be disclosed through labeling. Moreover, the FDA's exemption of GE foods from labeling requirements is strikingly inconsistent with its prior actions. In the past, the agency has acknowledged that unless there's a label alerting consumers to the fact that a food has been subjected to an extraordinary type of process, they are justified in assuming that it is not. For instance, in the case of food radiation, the FDA has stated, quote, in the absence of a statement that a food has been irradiated, the implied representation to consumers is that the food has not been processed, unquote. Genetic engineering presents a parallel situation, and research consistently reveals that the lack of labels has indeed conveyed an implied representation that the foods in American supermarkets have not been genetically modified. To the extent the majority of Americans have presumed they haven't been purchasing any, despite the fact for well over a decade More than half the processed foods in their supermarkets have contained ingredients from genetically engineered organisms. Thus, the lack of labels has seriously misled these consumers. Keeping the consumers in the dark about the existence of a fact that is highly important to them and thus quite material. Such a situation is at odds with the intent of the law. In addition to irradiation, several other processing methods must be disclosed via labeling. Thus, juices made from concentrate must be labeled with terms such as from concentrate or reconstituted as part of the name wherever it appears on the label. Now, this example highlights the striking inconsistency of the FDA's policy on GE foods. Although reconstituted orange juice must be labeled as such, even when the chemical composition of the juice is essentially the same as for unprocessed juice, oranges with artificially reconstituted DNA, from which the juice is derived, would not have to be labeled as genetically modified, even though the transformational process not only produces changes in the genome, but new chemical constituents throughout the fruit. So, in light of the FDA's brazen disregard for truth, science, and the law in regard to genetically engineered foods, and its willingness to regularly subject American families to novel foods that its own side has warned are uniquely hazardous, it would be a serious understatement to characterize the agency's actions as merely irresponsible. They are far more than irresponsible. They are reprehensible, and, as it has been shown, they are also illegal. They are unjustly depriving Americans of the protections Congress intended to put in place when it passed the Food Additive Amendment in 1958. Now, in such a situation, it appears to me that any state has the right to enact legislation that would compensate for the FDA's delinquency by affording its own citizens the protections of the law, especially because the FDA has taken no formal action in regard to GE foods to preempt states from regulating them. Therefore, it seems that the Connecticut legislature, or any state legislature, has the authority to enact legislation requiring the labeling of all GE foods sold within its state. Yet, I want to point out that the legislature could go even further than this. In the face of the FDA's dereliction of duty, it could decide to provide its citizens with the full protections of federal food safety law, not merely the partial protections of labeling of material facts. Not only could it ban any GE food from sale unless the food had been appropriately labeled, I think it could ban all GE foods that have not passed through the standard federal process for approving food additives. After all, since no GE food is GRAS, each one is on the market illegally, and none can be legally marketed unless and until it has been certified safe with the formal testing prescribed by the food additive regulations. Further, it's not a stretch to place the two requirements, the one for labeling and the one for food additive approval in the same statute. Excuse me, lost my place momentarily. Yes, it's not a stretch to place these two requirements in the same statute. Because just as a state's authority to mandate labeling stems from the fact that GE foods are not GRAS, so does its authority to mandate that all GE foods sold within its borders must first have been established safe by passing through the FDA's formal food additive approval process. Further, I want to make it clear that I'm not suggesting that Connecticut would set up a testing process of its own. That's already in place, put in place by the FDA for food additives. I'm really pointing out that a statute could make sale of GE food in Connecticut conditional on that food having successfully passed the federal government's testing procedures. So, in conclusion, it appears that Connecticut could, if its legislature so wished, require that the safeguards of the federal food safety laws be applied to all GE foods sold within its borders, restoring to its citizens the protections of which they've been unjustly deprived for 20 years. Thank you.
Thank you, Mr. Druker. Can you hear me okay?
Questions?
Yeah, can you hear me okay?
I'm having trouble hearing that. There's quite
Okay.
an echo in that microphone.
Well, yes, we have a good-sized crowd here who really appreciated your presentation. It's very well received. We just were joined by another legislator a few minutes ago, Representative Hennessy, and may we ask you questions now? Is that okay? Would any of our legislators like to ask a question? And if so, you need to go over to Attorney Summers to make the question. Representative Roy's on his way over.
Good afternoon. Thank you very much for your presentation. It was certainly enlightening. I have contended that Congress has turned its back on the citizens of this country and has let the industry make all the rules under which the industry works. Is that true, and what can we do to get Congress to pay attention?
Well, that's not true in respect to the U.S. Congress. It's true in respect to the federal executive branch and the Food and Drug Administration. As I mentioned in my presentation, the U.S. Congress in 1958 clearly evidenced an intention to protect American citizens from any food additive, any novel food additive that had not been proven safe. And that law is still in place. The FDA is breaking that law. Now, most members of Congress have no idea that that law is being broken because of the FDA's incessant lies, and I don't use that term lightly, because of the FDA's lies and deceptions, and because of the disinformation that is persistently spun out by the biotech industry and its allies, even in academia. So what we're finding is there is a plethora of disinformation that has hidden the facts from people, even from congressmen and women who have an interest in making sure that their will is not flouted. But so the problem is, it is the FDA that is callously disregarding the will of Congress as it's been expressed in the Food, Drug, and Cosmetic Act, and in particular the Food Additive Amendment of 1958. Congress needs to do nothing. We do not need to have any new laws at the federal level. The FDA, all we need, in fact, we don't need any new regulations from the FDA. All the FDA has to do is acknowledge that its rebuttable presumption of GRAS has been solidly rebutted. And that would be it. And they could say every genetically engineered food must now file, the manufacturers must file a formal food additive petition, and each one will have to go through the food additive process with the standard testing and be demonstrated safe. That all has to be public and open. One way or the other, that will eventually have to happen. One of the ways it may happen is for a state like Connecticut just to blow the whistle on the FDA to pass a statute in which it cites findings of how the FDA is misstating the facts and violating the law, and saying until the FDA follows the law, we're going to afford our own citizens the protections that they are being illegally and unjustly denied. That's the way I look at it.
Thank you. I think that's probably a good road to take. I think that this committee should take up that very seriously. But at the same time, I just can't imagine that all those Congress people down there are just not paying attention, or if they are, that someone isn't saying something. We know the FDA and Monsanto and the Department of Agriculture are all going through doors and helping each other, but they're not helping us.
Well, I think that's a very correct statement. They are not out to help the American public. And as I mentioned, and it bears repeating, for many,
I'll be happy to do
the
that.
FDA has acknowledged that it is operating under a policy to foster the U.S. biotechnology industry. It, at the same time, claims it can fulfill its promotional role and still adequately fulfill its regulatory role. But I think the facts have proven otherwise. The FDA has completely compromised its role as a valid regulator of genetically engineered foods in favor of promoting Monsanto, DuPont, and the biotech industry. And the memo that I wrote that has been distributed to you summarizes the extent to which the FDA has violated the law. And for anybody who would like to see a more thorough and compelling presentation, I recommend that my book is read, Altered Genes, Twisted Truth, especially Chapter 5, which goes into the law and how the FDA is breaking it in thorough and unfortunately discouraging detail. And if you have any acquaintances, or there are any people on the committee, or any people lobbying you from the side of the biotech industry that try to protest anything I've said, read that book, especially Chapter 5, and then challenge them to read it, and then get back to you to see if they find any facts on which to mount a counter case.
Thank you. We'll do that.
Representative Becker will be our next questioner.
Good afternoon, Attorney Druker. I have a few questions for you. We're still trying to understand the facts and trying to get our arms around the legal niceties and the like. I'm not an administrative law expert by any stretch, but so help me out with this. So the FDA, I assume, has the power to label a product as GRAS. Is that correct?
I'm sorry, you asked whether the FDA has the labeling power, and I didn't hear the last part.
Yes. Is the FDA that has the power to label a product as GRAS, generally recognized as safe?
Well, actually, they're not labeling a product as GRAS because labeling is something that should appear on a package label. But the FDA does have the power to promulgate a rule that a particular additive is GRAS. But in the past, the FDA has always done that through formal rulemaking procedures. In the case of genetically engineered foods, they've not gone through those procedures. They have merely issued a policy statement that makes a rebuttable presumption that all of these foods are GRAS. And by the way, that's a blanket presumption. It was made in 1992, but it covers every genetically engineered food of which the FDA was aware at that time, and any food made in the future. It was a blanket presumption, and yet the FDA emphasized it was rebuttable. That's why it said it didn't amount to any actual agency action, and that's why it claimed it was exempt from having to conduct any environmental impact study under the requirements of the National Environmental Protection Act. It said we don't have to do these studies for genetically engineered foods because we haven't even taken any state action. If they had officially promulgated a rule, they would have had to. I and several other attorneys who studied this surmise that one reason they didn't want to make a formal rule is just so they could avoid all the requirements of the various laws. So they could basically have tremendous wiggle room. And boy, have they given themselves a lot of wiggle room. And I think, but do you want to follow up? Have I answered your question?
I guess in part, so if they had made a rule, all right, and if they had done it pursuant to scientific procedures that were not proper for whatever reason, not properly conducted, they actually went through the work in an improper way and actually issued a rule, then how would one challenge that rule through the administrative law process? You could appeal it somewhere in the FDA, exhaust your possibilities there, and then be able to bring a court action? Or what kind of, if you try to go the legal route, how would you challenge something like that?
Well, I think today, given the state of the evidence and the FDA's ongoing fraud, I believe that a lawsuit could be brought in federal court that would challenge what the FDA is doing. I believe that could be done. But again, I believe there are other ways too. Of course, all that would need to be done is if there's widespread public recognition of or media recognition, media coverage of the FDA's fraud, and growing outrage among the public, and then outrage among many Congress people. And I think we would find a change because the change could easily be done. All the White House would have to do is just basically give the FDA the directive to stop coddling GE foods and to apply the full strictures of the law to them, in which case none of them would any longer be able to be on the market unless and until it had gone through formal food additive approval. And that takes some time to do it. So I really feel that all of the evidence that is necessary to create the wave of knowledge, the wave of public opinion that is needed, is in your possession now, especially if you read my book. You would have all the information you need. Yes, a lawsuit could be brought, and I think it would be nice, but I think that the legislature could, in several other ways, bring this information to the fore. And of course, if it enacted a law that had these findings, as part of the findings justifying why it is taking the measures of requiring labeling and requiring that every genetically engineered food first have been approved safe through formal food additive process at the federal level, that in itself would make a major statement. That could not be ignored. So that's something that I think could be an option that could be seriously considered, although I'm not advocating you do it.
Right, I'm just curious to know, so you're a public interest attorney, and if you believe that a lawsuit would be possible based on the evidence you've collected, I guess the natural question is, why haven't you brought that lawsuit?
Oh, I did. That was the lawsuit that the Alliance for Biointegrity initiated and filed in 1998. That was the lawsuit that was the vehicle for forcing the FDA to divulge all of its files. That's why I know and could read to you quotes from the FDA's memos. If we hadn't brought that lawsuit, the FDA would still be completely getting away with all of its lies. Its cover-up of what its scientists said would be complete, because the only way we know what the scientists said is the federal court, as part of the discovery process, compelled the FDA to hand over 44,000 pages of its internal documents. Now, during the course of that lawsuit was, we were challenging the FDA's policy. We were challenging its GRAS presumption. We were challenging its refusal to label. The court, the memo that I've distributed goes into this in detail, and chapter 5 of my book in even more greater detail shows that the judge in our case acknowledged that we, as of the time of filing of our suit, through the filing of our suit, we had presented evidence showing there was substantial disagreement about the safety of genetically engineered foods in the scientific community, because 9 of our plaintiffs were well-credentialed life scientists. One was a molecular biologist at the University of California, Berkeley. One was a molecular biologist at State University of New York. Another was a professor at New York University. They had very good credentials. And every one of them declared in signing on to the lawsuit as a plaintiff that they had not seen any evidence that any genetically engineered food was safe, and that they regarded them as entailing unique risks above risks entailed by their conventionally produced counterparts. And we also submitted other evidence. And the judge acknowledged essentially that we had shown that as of that time, genetically engineered foods were not GRAS. But what she said was, I'm going to narrow the issue to the very technical issue of administrative procedure law as to whether at the time that the FDA issued its policy statement in May of 1992, its administrators acted arbitrarily and capriciously in presuming that genetically engineered foods are GRAS. Now, as I've discussed with you already, and as my memo and book go into in more detail, the FDA's own files show that the agency knew there wasn't even consensus of safety within its own scientific staff. It knew that the overwhelming opinion of its own scientists was that GE foods cannot be presumed safe, that they entail unique risks. And it also knew, and its own files again admitted, that there was not adequate evidence on which a consensus of safety could form anyway, even if every opinion was, yes, they can be presumed safe. So, how did the judge get away? How did the judge end up saying that the FDA had some rational basis for presuming they were GRAS? That's all she said. As of May 1992, the FDA administrators were not arbitrary and capricious in presuming that every genetically engineered food is generally recognized as safe. Well, she said that all of the statements from FDA scientists could be ignored, that the FDA administrators didn't have to pay any attention to them. Essentially, that was excluded evidence too. She said that they had the discretion to ignore mere opinions of their underlings. Now, by the way, I don't have time to go into it now, but my book thoroughly destroys that argument in terms of federal case law. And secondly, but then one might ask, well, how did she deal with the admission in the FDA's own files that there's no evidence on which to form a presumption of safety, that there's no evidence demonstrating that any one of these foods is safe? That evidence was known to the FDA administrators as of May of 1992. So how could the judge have gotten around that? The interesting answer is she got around it by ignoring. Although in her initial statement, she fully acknowledged that GRAS criteria, that there were two criteria, two requirements for GRAS: scientific consensus and technical evidence of safety on which that consensus rests. And we made thorough arguments in every brief we submitted to the court, driving home the point that there was no evidence of safety and that the FDA's files showed that as of May 1992, its administrators knew that there wasn't. She never came back to that issue. She completely evaded addressing it. And somehow she's gotten away with that too. None of the law review articles I've seen that have mentioned that case even were aware that the judge completely sidestepped addressing that issue. Because had she addressed it, she could have never come down on the side of the FDA. So you may be asking, well, why didn't we appeal? We did appeal. And again, my memo explains, and as the book explains in great detail, after we filed the appeal, the FDA came out with a statement that it was going to, for the first time, initiate some regulations covering genetically engineered food. Now, had it done so, those regulations would have then become what would have had to have been challenged, and our lawsuit on the superseded May 1992 policy statement would have become moot. So when it seemed that the FDA was really going to go ahead with this, we dropped the appeal. At the last possible day, we could drop the appeal without going ahead and then forfeiting it, because we were waiting for the FDA to come out with its new regulations, which we realized were going to be minimal and still inadequate, and then we knew we would have a solid case to win, because all of the evidence we had brought for our lawsuit couldn't have been excluded then, because the FDA was aware of it by the time they promulgated the new regulations. So we knew we'd be in the driver's seat. What happened? The FDA, by the way, as it turned out, the FDA pared down the proposed regulations to only one, that there would have to be mandatory 90-day notice of intent to market the genetically engineered food. Now, by the way, that changes things, because currently, no manufacturer even has to give the FDA notice that it's going to put a genetically engineered food on the market, which means that any country or any unscrupulous manufacturer could have been dumping genetically engineered foods on our market for all these years, completely in compliance with the law as the FDA defines it, because the FDA doesn't even require prior notification. So that was going to be the only change, a regulation requiring prior notification, but not requiring any testing. So what happened? The FDA sat on that for over 2 years, and then it announced that it was putting it on the back burner, and it did not anticipate finalizing that regulation anytime in the foreseeable future. So what happened is we brought a lawsuit. The judge ruled against us on very, very flimsy grounds. We appealed. Then we dropped the appeal because we were led to believe by the FDA that our appeal would basically be a moot issue. We waited to sue again. Now we can't sue again on the new regulation because there isn't a new regulation. And it seems that my organization is barred from bringing another lawsuit. But that wouldn't bar another like-minded organization who has the facts and has the gumption. So that's a long answer, but you know, it's kind of, there's a lot involved there.
Thank you very much.
I think that's it for our questions. Mr. Druker, thank you very much for your time. I think your presentation was very well received.
You're very welcome, and I will be very happy to provide more information as you may wish. And my recommendation for anybody that wants more information is to read my entire book. It's out as part 1 right now, the first 8 chapters. But at least at minimum, read the introduction in chapter 5. And then after having read it, if you still have questions and want to go more deeply into any area, I'll be very, very happy to take it as deeply as you may wish.
What's the name of this book?
What's the name of your book?
Altered Genes, Twisted Truth.
Thank you.
It's currently only available as an ebook. I don't want to bring out the print version until the whole book's ready, but it's available on Amazon and Barnes & Noble and Kobo.
Thank you very much.
Well, thank you very much.
And his memo that he referred to will be distributed to us shortly. Okay, at this point, we're going to have a brief discussion, which originally we hoped would be larger. We labeled it on the agenda as discussion of model legislation, but would anyone like to, the legislators here, like to share on the bills that we've looked at from New Jersey and Vermont, or the Connecticut bill, or things that we want to focus on in the future? I think this will be a future discussion as well, but is there anyone who'd like to speak on this at this point? Representative Roy.
Thank you, Mr. Chairman. I think that we have to look very closely at not necessarily going to the labeling, but to get that enforcement of the regulations that are in place now before a GMO product can be sold in this state. That's certainly going to slow commerce down a little bit, but I think that if Congress, and then I still say they turned their backs on it, but by not providing the proper oversight of the department. But if that's the case, then let's put that out there and, insist that we protect Connecticut citizens from whatever might be out there. And I would rather err on the side of our citizens than on the side of the industry. Thank you.
May I, Representative Roy, could you just then state that in a simple multi-step process to how we should go with this?
First, I think as part of the bill, we should have a section that deals with insisting on our state only sell GMO products that have gone through the proper screening down in Washington, that the FDA does its job and that Congress oversees the FDA or the Department of Agriculture, so that is done. And this is essentially to protect our interests, protect our citizens, which obviously has not been coming from Congress, and I know he says Congress is not to blame, but somebody should be watching. Somebody should be going through and finding the lapses, or not so much lapses, but the just complete disregard of what people have asked for. And I think that we ought to call them on that. Thank you.
Thank you, Representative Roy. Representative Camillo.
Good to see you, Representative Miller. Quick question. Have we reached out to any of our congressional delegation in Washington? And if so, who's behind this effort?
Yes, I asked Senator Blumenthal and Congressman Courtney's office in particular. The reason I thought Congressman Courtney would be helpful is that he's the first member of the Connecticut delegation to serve on the Agricultural Committee in a long time. So he has been looking at this. When I spoke to him this fall on it, he suggested that everyone in the country is watching the ballot initiative in California, which, as you know, failed. But right now, he and Senator Blumenthal and our whole delegation is in Washington in trying to avoid the fiscal cliff.
Thank you. Yes, they are. I did know Senator Blumenthal is behind this. We did the event with him in Greenwich, but I should have stated more clearly also about the congressional delegation. But certainly, maybe we could all reach out to. There's only 5 of them, so maybe we could, if we can get a couple of them on board, I think that would help to have an anchor somewhere. Because certainly, expecting Washington to do something, we won't even have any of our own advocating for us. But I'm sure that shouldn't be a problem. But thank you.
Representative Kupchak.
Thank you, Chairman Miller. Mr. Druker said it was basically, he said it really wasn't Congress, he said it was an executive branch. Essentially, the president would have to send a directive down to the FDA to start enforcing the current laws, that as an additive, it has to be tested as an additive and not just, for GRAS. So, I mean, maybe we ask the delegation, whoever would be interested in supporting this, or not even just supporting the GMO task force, but supporting writing a letter together as a delegation from Connecticut asking the executive branch to enforce that law and ask if they'll respond, or at least ask why the FDA is not enforcing it. It seems like something simple enough. And I don't think even if the congressmen don't necessarily have to be in support of this either way. They could ask the question, simply asking the question on behalf of Connecticut residents why they are not enforcing. And see if the executive branch answers the question.
Good idea. Representative Hennessy.
Thank you. I'd like to concur with Representative Roy as to the proposed legislation in the sense that the labeling is more of a benign type of, oh, by the way, it's got GMOs, whereas the idea of having the process that's already in law be enacted, be enforced, actually goes to the crux of, well, is it good for us, or is it harmful? And shouldn't we be doing that prior to allowing it to be distributed for consumption?
Anything else?
Just,
Representative Kupchak.
Are we planning to have another meeting before the deadline for legislative deadline? Are we going to have?
Yes, but I'm unsure of that date at this point.
It's January, what is it? January 8th? That's right, that's 18th. Is it the 18th? The date, the deadline? So I mean, we're obviously going to have a couple meetings to try to decide what we are going to do and what it's going to look like.
Yep, I think we'll try to fit at least one in if we can.
Don't celebrate too much.
Okay. Well, we will announce that meeting as soon as we figure out the time and the subject matter. And if there's no other burning desires here, let's adjourn this meeting. And thank you for your participation. And thank you, members of the public, for being here.